Surveillance in workplace investigations is tightly regulated under privacy and data protection law. The guiding principle is always the same: balancing an employer's legitimate business need to investigate against an employee's reasonable expectation of privacy. Courts typically apply a two-part test. First, did the individual have a subjective expectation of privacy? And second, is that expectation objectively reasonable in the eyes of society and the law? From there, investigators must carefully assess whether surveillance methods are proportionate, necessary, and legally justified. Let's start with physical surveillance. In general, surveillance is permitted in public or semi-public workplace areas such as lobbies, break rooms, shipping areas, and parking lots. These are spaces where employees have a reduced expectation of privacy. However, some areas are strictly off-limits. Restrooms, locker rooms, and changing areas are almost always protected due to the high expectation of privacy. Surveillance in these locations is typically prohibited. Similarly, monitoring an employee's private residence, backyard, or personal living space is considered an unlawful intrusion. Even where surveillance is allowed, it must be limited in scope and duration. Excessive or unnecessary monitoring can quickly become a privacy violation, especially if it captures personal or non-work-related activity. Electronic monitoring introduces another layer of complexity. Laws such as the Electronic Communications Privacy Act in the United States and equivalent provisions in other jurisdictions restrict the interception of private communications. Depending on the jurisdiction, consent rules may vary, with some requiring only one-party consent and others requiring all-party consent for recordings. A key principle in workplace monitoring is the personal call rule. If an investigator or employer is monitoring a business call and it becomes clear the conversation is personal, monitoring should stop immediately. There is also an important legal distinction between data in transit and stored data. Intercepting live communications is much more strictly regulated than accessing stored information on company systems. Digital devices and workplace technology require special attention. Employers generally have the right to monitor activity on company-owned systems, especially when clear policies are in place. However, even on company devices, employees may still retain a limited expectation of privacy for personal information, particularly when personal use is permitted. This expectation can be reduced through clear written policies, acceptable use agreements, and system login banners that notify users of monitoring. Bring your own device or BYOD environments are more sensitive. Personal devices such as smartphones and tablets generally cannot be accessed without explicit consent or a clear legal and contractual basis. Video surveillance is one of the most sensitive investigative tools. Covert surveillance is considered highly intrusive and should only be used as a last resort, after less invasive methods have been exhausted. Overt surveillance, such as visible security cameras, is generally permissible when properly disclosed to employees. However, video surveillance must be used strictly for its intended purpose. Footage collected for security reasons should not be repurposed for unrelated disciplinary actions unless legally justified. Audio recording introduces additional risk and may trigger criminal liability if private communications are intercepted without proper consent. Location tracking through GPS also has clear limits. Tracking company-owned vehicles is generally permissible, provided employees are informed and there is a legitimate business reason such as safety or operational efficiency. However, tracking an employee's privately owned vehicle without consent is typically unlawful and can create significant liability. Violations of surveillance limitations can lead to serious legal consequences. Common claims include intrusion upon seclusion, which involves offensive interference with private affairs, and publication of private facts, where sensitive information is disclosed without a valid business reason. In some cases, false light claims may also arise if investigative information is presented in a misleading or damaging way. Ultimately, surveillance in workplace investigations is not about what is technically possible. It is about what is legally appropriate, proportionate, and justified in the circumstances. A careful, disciplined approach protects both the integrity of the investigation and the legal position of the organization.